Product liability. During this block, our learning objectives will be: 1. To identify the theories of liability and product liability cases, and 2. To explain market share liability. Product liability is the area of law in which manufacturers, distributors, suppliers, retailers, and others who make products available to the public are held responsible for the injuries those products cause. There are three theories of recovery for product liability. One is negligence, two is strict liability, and three is breach of warranty. We're going to take them one at a time. Product may be defective through a manufacturing defect, a design defect, or inadequate warnings. Now, I am absolutely and completely sure that all of you have had experiences with products that were not manufactured properly, right? A lot of things that you get that are really, really cheap, right? They're designed to do a specific thing, but they fall apart relatively quickly because of how they're made. That would be a manufacturing defect. Now, there are other things in which you see a design defect. All right, for me, a real big example of this would be really high stiletto heel shoes. The purpose of shoes are to protect your feet and enable you to walk comfortably. 8-inch stiletto heels, from what I understand, are not comfortable, and they're very, very hard to walk in. In fact, many people break their ankles while wearing these shoes. Now, what's the problem there? They're not designed to do what they should be designed to do, namely, keep you comfortable and safe while you're walking. They look good, but they don't work. Inadequate warnings? Well, a manufacturer has to let you know in instructions how to use products. And conversely, they have to let you know what not to do with products. Real good example of this would be if you go to IKEA and you buy a bookshelf, right? If you look in the instructions, they'll always have a warning, right, that there's a tip over hazard, right? If a child were to climb up on a cabinet, the cabinet could tip over on them, right? So they always recommend that you anchor those cabinets to the shelf, to the wall. Now, products liability is a subset of negligence. What does this mean for us? This means that the burden of proof is on the plaintiff. The plaintiff must show that the defendant manufacturer or seller owed a duty of care to the plaintiff, that the defendant breached the required duty of care by supplying a defective product, and 3, the defendant's breach of duty caused the plaintiff's injury. Duty breach, causation, and harm. Number 4, the plaintiff actually suffered an injury. I'm going to say it again. Duty breach, causation, and harm. Now here's our negligence summary. Who can sue? Any foreseeable plaintiff. Who can be sued? Who's liable? Any commercial supplier in the distribution chain. Now, real important concept. What is a distribution chain? Well, it's everyone, every person, every organization, from the manufacturer to the wholesaler to the retailer to the salesperson. This would be the distribution chain. Each one of those parties would be liable, could be named in a lawsuit. Now, what defenses are available to defendants? The first is an assumption of risk. Basically, they're alleging that the plaintiff assumed the risk for harms normally associated with the use of that particular product. 2, contributory, comparative, or modified comparative negligence. We're going to go into more detail on that because that's pretty long. 3, misuse. 4, state-of-the-art defense. And 5, compliance with federal laws. Now, as I said, assumption of risk refers to situations in which individual acknowledges the risk associated with an activity, but chooses to take part regardless. In other words, the plaintiff knew that the activity could possibly result in physical injury or property damage, but decided to assume the risk for fun. Right? One of my favorite examples is paintball, paintball, paintball. When you go to play paintball, can you get hurt playing paintball? Yes, when you get shot by a marker, it hurts. However, when you get there, before they let you play, they have you sign a release where you assume the risk for injuries normally associated with that particular activity. Why do you do it? Because you expect to have fun. Number 2, contributory, comparative, or modified comparative negligence. All right, what is contributory negligence? It's a concept of contributory negligence used to characterize conduct that creates an unreasonable risk to oneself. The idea is that an individual has a duty to act as a reasonable person. When a person does not act in a way an injury occurs, that person may be held entirely or partially responsible for the resulting injury, even though another party was involved in the accident. Now, how do we say this in English? You have a duty to look out for yourself. If a person fails to look out for him or herself and does something that places him or herself at risk, they are responsible. Two, comparative negligence. Most states have now adopted a comparative negligence approach to contributory negligence, wherein each party's negligence for a given injury is weighed in determining damages. Now, what does this mean? This means that if you have contributed to the harm that you suffered, the damages you receive will be prorated, adjusted by the apportionment of the value of the damage you caused to yourself. In other words, the defendant will not have to pay everything, only the part that the courts deem that defendant to be responsible for. Now, there are two approaches to comparative negligence. First, you have pure comparative negligence, where the plaintiff's damages are totaled and then reduced to reflect their contribution to their injury. And the second is modified comparative negligence. And this is the most common approach, right? The plaintiff will not recover if they're found to be equally responsible or more responsible for the resulting injury. So if you are 50% or more responsible for the injury that you incurred, you will not recover damages. That means it's your fault you got hurt, not the other parties. Misuse. This one should be very, very evident. If you use a product for something other than its intended purpose, that's a defense that the defendant can claim, right? Example you see here is someone using a screwdriver. Using a butter knife as a screwdriver, right? If that butter knife slips and they get injured, whose fault was that? Was it the manufacturer's fault? I say no. What was the purpose of a butter knife? To cut butter. Is the purpose of a butter knife to drive a screw? The answer is no, right? The manufacturer or the seller would not be responsible. State-of-the-art defense. The state-of-the-art defense allows the defendant to be absolved of liability if he can prove that the state of technical and scientific knowledge at the time when he put the product into circulation was not such as to enable the existence of the defect to be discovered. An historic example of this would be the use of asbestos and lead paint in buildings. In the early to middle part of the 20th century, right, that was very common practice. Asbestos was a very good insulator. It's fireproof. Lead paint, cheap to make, covered effectively. Based on the science and the technology available at the time that these products were being used, manufacturers or the users had no idea they were hazardous to the health of people living in structures or working in structures where they used asbestos or lead paint, right? That was their defense until the scientific and technological evidence or techniques had advanced to the point where they knew beyond a doubt that these products were dangerous. So prior to knowing, they were not liable. After finding out, they were. Compliance with federal laws. For the most part, product liability law is governed by state law. Occasionally, the federal government will move to preempt an entire area of product liability law from state control in order to protect certain groups of manufacturers. Currently, during this epidemic that we're going through, the COVID-19 coronavirus, there's been a shortage in masks, not just for the population, but also for first-line providers of services. So the president asked 3M to produce more masks, right? They could produce 5 million masks a day. They choose not to because they don't want to be held responsible for people misusing the mask. And they asked the president and Congress to give them a waiver of liability. So if anybody got sick while wearing these masks, they would not be responsible. Now, they made that request. The request was not granted as of the time of this recording. But if it is, right, the federal government is preempting state governments from suing 3M for manufacturing defective products. Now, as I said, this has not yet been granted at the time of this recording, right? But if it is, if you wear this mask and you contract COVID-19, the coronavirus, you could not sue 3M. Why? Because they're in compliance with federal laws. What damages can a plaintiff hope to recover? Well, you can recover damages for personal injury, meaning if you were injured by this product, a broken arm, a broken leg, an illness, you can sue. You can also recover damages for property damages, right? If your property is damaged because of a defective product, you're driving your car and the brake pads that were installed on the car are defective, you crash, you're not injured, but your car is damaged, right? You can cover damages to repair your car. Proof of strict liability as it relates to product liability. The plaintiff must show that the product was defective when sold. The product was so defective that it was unreasonably dangerous, and the product caused the plaintiff's injury. Now you remember, strict liability is liability without fault. Strict liability summary: who can sue? Anyone harmed. Who can be sued? Any commercial supplier in the distribution chain. Now you're going to start seeing a lot of things that repeat, particularly what kind of damage you recover and who you can sue. This is pretty constant when we talk about product liability because once again, right, you're dealing with anyone in the supply chain and anyone, as a general rule, who's hurt by this defective product. Now, what defenses are available in a strict liability claim? One, product misuse. We talked about that. The plaintiff has not used the product for its intended purpose. Two, assumption of risk. All right, the plaintiff assumed the risk of any harms normally associated with the product. Three, lapse of time. Now, lapse of time has to do with how long you have to file a lawsuit. If you're injured by a product, the time starts running as of the date that the injury occurred, and in some cases, whether or not you're aware of the injury you sustained. Right? You have a specific period of time. It might be 2 years, it might be 4 years to bring a lawsuit. It varies from state to state. But once that time has run, their defense is lapse of time. Yes, 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 our product caused the injury, but you waited too long to claim it. What damages are recoverable? Familiar themes, personal injuries, property. Now we have a breach of warranty. What's a warranty? A warranty is a guarantee or binding promise regarding a product. Who can sue? Injured party with regard to a warranty must be a buyer, a buyer's family, or buyer's guest. In this case, privity is required. What is privity? Privity is a legal term for a close, mutual, or successive relationship to the same right of property or the power to enforce a promise or warranty. Right? Now, this is very, very important in law. Basically, what it comes down to, you're privy to a warranty if you're one of the people who agreed to the warranty. You were part of this particular contract. Now, once again, it extends to others based on their relationship with the person who actually entered into the agreement. Who can be liable? I bet you figure this out. Any seller. Now, what defenses are available? Once again, assumption of risk, product misuse, and now we've added a disclaimer. A disclaimer is generally any statement intended to specify or delimit the scope of rights and obligations that may be exercised and enforced by the parties in a legally recognized relationship. Now, I don't know if you've ever gone to buy a used car or really any product and it has this sign that says sold as is. Right? Basically, when you see that sign sold as is, it means the seller is not promising that this is a good car, that the car will work. They're telling you what you see is what you get with no further promises. Now, sometimes when you go to buy a used car, the dealer will have something called a limited warranty in which they specify exactly what they cover, they limit it, and exactly how long the coverage will remain in place. Right? If anything outside of what they say they cover breaks, or if the things they cover break after the stated time, Because of the disclaimer, you are barred from suing. What damages are recoverable? In this case, economic damages only, right? From a breach of warranty lawsuit, all you can get is money. Not bad. Proof of express warranty. Now, in order to prove that there was a warranty, the plaintiff must show that the representation was the basis of the bargain. In other words, the reason why you entered this particular agreement was because of the warranty. They have to show that there was a breach of representation, that you misstated. Now, this is a subset of a warranty, right? This is an implied warranty of fitness for a particular purpose. Now, it's exactly what it sounds like, for a particular purpose. This means that a product is guaranteed for a particular purpose beyond the lower threshold of merchantability. Implied warranty of merchantability. Right? What is merchantability? It means that a product is fit for its intended purpose. Right? It's fit to be brought to market, and it's fit for you to buy it or for them to sell it. That's what it means. It's fit for its intended purpose. Going back to the example of the butter knife used as a screwdriver, right? The implied warranty of merchantability was that you could cut butter with that knife. There was no implied warranty of merchantability saying that you could drive screws with that butter knife. In order to win this lawsuit, the plaintiff must show that the goods are fit for the purpose for which they are being sold and used. For example, the goods are fit for ordinary use. Now, I want to emphasize ordinary use, nothing extraordinary. Ordinary use. Let me go back to that for a second. The customer relied on the seller's particular skill and judgment. I've just come into a lot of money because I hit lotto, and I'm talking to my Uncle Dave, and Uncle Dave says, if you want to make money, you got to buy a racehorse. And I said, what do I need a racehorse for? He said, well, you buy the racehorse so that you can put the racehorse out the stud, and you can make lots of money on stud fees. Basically, studding is breeding horses. That's where the money in racing is. So I go to a seller of racehorses, and I tell him what I want to do, but I've really never examined a horse up close. I don't understand the mechanics of all these things. And the seller brings out this beautiful horse, great big 17-hand horse. That's a big horse. All these muscles, shiny black coat, great teeth, bright eyes, powerful animal, winning all these races. I look at the horse, I look at the eyes, I look at the teeth, because that's what I was taught to do. I smack him on the butt because you can check out the horse's strength and muscles by the hindquarters, right? And I say, horse looks good to me. Now, what the seller did not tell me was that the horse was a gelding, not a stallion. A gelding is a stallion that was fixed. A gelding cannot produce babies. I did not know. The seller knew that I was buying a horse to breed. Because I didn't know about horses, I relied on the seller's skills and judgment. Right? We had an implied warranty of fitness for a particular purpose, mainly to breed the horses. I would prevail because I was misled. Market share liability theory. When a plaintiff cannot trace a product to a particular manufacturer and several manufacturers produce the same product, A court may use the theory to impose a portion of fault on a number of manufacturers. Right now, a lot of times you see things that are very, very generic, like milk, like potatoes, and you got a whole lot of people that produce and sell milk, produce and sell potatoes, and a person is injured because the milk sold or the potatoes sold were not marketable, they were not fit for the intended purpose. If you cannot trace it back to a specific seller, every manufacturer can be blamed. Now, recovery may be possible today because of the market share theory, which generally requires that the plaintiff show, one, all defendants are tortfeasors. Two, the allegedly harmful products are identical and share the same defective qualities. Three, the plaintiff is unable to identify which defendant caused her injury through no fault of her own. Four, the manufacturers of substantially all of the defective products in the relevant area and during the relevant time have been named as defendants. These are the four requirements to recover. If you leave one person out, you won't be able to cover. Once again, these four requirements are all or nothing. Each one must be met. Each one must be met.